Okay, we're going to be talking today about journalists and the law. Specifically, we'll be looking at a foundation for the First Amendment protection of the freedom of speech, the freedom of the press, in way of the marketplace of ideas, a philosophy that guides this notion that we should have a free and informed citizenry. We'll be looking at how that has been challenged in laws, specifically sedition laws, which is government censorship at various times in our country's history. And then we'll move at the end to look at how the rights of students have been interpreted in terms of their free speech rights inside schools, both the liberties that they should enjoy and also some of the parameters that have been set to protect the interests of school administrators as well in trying to conduct and create an educational environment. So let me know if you have questions. In the meantime, enjoy the video. We're going to move in now to talking about journalists and the law. We're going to talk specifically here about some of the protections that are afforded to journalists and how some of those protections have come from battles with those in power over the years, that some of the protections have been the result of legal cases in which the questions of to what extent journalists should be protected have come to the courts. So to start off with, we'll look at take a look back here at the history of the press and some of the laws that were set up early in the formation of our country. In 1791, the First Amendment was established to protect the freedom of speech and of the press, and this was meant to protect against seditious libel laws. Licensing, so where previously the Crown had required people that were publishing material with a printing press to receive an official license from the Crown to do that. The First Amendment was meant to protect against what we call prior restraint, so holding information before it can be published because those in power, the government, the Crown, whoever it might be, doesn't want it going out, that they want to withhold that information from the public. All of these had been used by the British in colonial times, and so the colonists in drafting the Constitution wanted to explicitly say that the freedom of the press and freedom of speech should be protected. Now there was an irony here, of course, in that during this time pro-British speech was not all that popular, and so there's what we call a chill on pro-British speech. Those that might have been apt to speak up in defense of the Crown, what were called loyalists, they actually would be more intimidated during this time because the popular rhetoric and the popular positions held at that time were those generally that were pro-revolutionary. But this idea of a free press, free speech, and informed citizenry it came about through a philosophy that was popular around this time called the marketplace of ideas. And this is first identified in John Milton's Areopagitica in 1644, his polemic against Parliament's efforts to license the press. He referred to this as a contest of forces. He says that though all the winds of doctrine were let loose to play upon the earth, so truth be in the field. We do injuriously by licensing and prohibiting to misdoubt her strength. Let her and falsehood grapple, for whoever knew truth put to the worse in a free and open encounter. And so this is a very idealistic notion that truth will win, right? That if we allow as wide a berth as possible for ideas to be presented in the common arena of conversation, in this marketplace of ideas, then in the end, we as humans will recognize truth for what she is and come to embrace her. In 1859, John Stuart Mill published his essay titled On Liberty. John Stuart Mill, by the way, you also may have heard of from being one of the primary philosophers who proposed and promoted the philosophy of utilitarianism. But in his essay on liberty, his words were, "We can never be sure that the opinion we are endeavoring to stifle is a false opinion, and if we were sure, stifling it would be an evil still." So again, following this idea that humans are best served when we are given a wide array of ideas and exposed to a diverse collection of thoughts, so that we can then collectively and individually determine what we hold to be true. But if we don't have that marketplace, if we don't have that array of ideas, then we're limited, and truth can never demonstrate herself by proving superior to false opinions. And so that's why Mill says we can never really be sure, and even if we could be, stifling a false opinion would still be an evil thing to do, as he puts it. All right, so in this context then we had in 1798 John Adams signed into law the Alien and Sedition Acts, which a Federalist Congress was trying to silence Jeffersonian newspapers at the time that were critical of Adams. And so 8 of 15 prosecutions under this law were newspaper editors. So imagine charging publishers and editors of, say, the New York Times and the Washington Post and the Wall Street Journal and the LA Times today. Imagine bringing them all up on charges related to censorship, and that's essentially what happened under these Alien and Sedition Acts. The constitutionality of this law was never tested by the Supreme Court, and it was generally upheld, and the defendants were convicted by Federalist judges. But the law backfired on Adams. It was a very unpopular law, and many claim that it was the reason that Adams did not get reelected. The Alien and Sedition Acts expired in 1801. Jefferson pardoned all who were convicted under the law, and Congress eventually repaid fines that it had levied against those that it had convicted. As we move forward into the period of 1830 to 1860, government mostly in the South aimed to shut down the abolitionist press. And U.S. and Confederate states both censored the press during the Civil War. In the latter 19th century, censorship turned to focus on groups like labor unionists, anarchists, birth control advocates, and other, quote, free thinkers, which is a term that we might now apply to people that we would call atheist or agnostic, non-religious individuals. To give you an idea of sort of the tension that was present in America with these groups at the time. In 1901, McKinley was assassinated by a man that many believe was an anarchist. And so when we see fringe groups rising up and speaking out, we often see movements by the government to try to silence these groups for various reasons, sometimes for legitimate concerns of safety, or perhaps misguided concerns of safety, but also many times just because it challenges the existing power structures. And one of the most popular ways to try to combat that challenge to power is for the government to crack down and censor speech that these groups are putting out. In the 20th century, as we move into the period of World War In 1917, we had the Espionage Act, and in 1918, we had an amendment to that act called the Sedition Act. World War I was highly unpopular among many people in the country. It was seen as an imperial war, as a chance for America's farmers and industrialists to profit off of the war effort, and many patriotic Americans got excited to demonstrate military capability in Europe, but many immigrants who were growing in number in America at that time were upset that this war was going on in their homeland. They had people, family members, loved ones that were experiencing the plight of war in their homeland, and so it was very unpopular among many of the people in the immigrant communities. So as these people started to speak up in opposition to the war, in 1917 the Espionage Act was approved by Congress, signed by Woodrow Wilson. It dealt mostly with espionage problems, but the law also provided that it was a crime to willfully convey a false report aimed in opposition to World War I. That it was a crime to cause or attempt insubordination, disloyalty, mutiny, or refusal of duty. It was a crime to willfully obstruct enlistment or recruitment, and that material violating the law could not be mailed. So here we see a restriction on information, not just actions or behavior, but the distribution of information also being restricted. Like I say, in 1918, the Espionage Act was amended with the Sedition Act, and this added that it was a crime to utter or print or write or publish disloyal or profane language that was intended to cause contempt or scorn for the federal government, for the Constitution, the flag, or the uniform of the armed forces. And 2,000 people were prosecuted under the Sedition Act. 900 were convicted. They received as much as 20 years in prison, and they had to pay a fine of up to $10,000. The U.S. Post Office during this time censored newspapers, books, pamphlets, and the states also adopted similar sedition laws to the Federal Sedition Act as well. So the Espionage Act and the Sedition Act came before the Supreme Court in the case of Abrams versus the United States in 1919, and the decision by the Supreme Court upheld those acts. However, Justice Oliver Wendell Holmes said in his dissenting opinion, "When men have realized that time has upset many fighting faiths, they may come to believe even more than they believe the very foundation of their own conduct, that the ultimate good desired is better reached by free trade in ideas, and that the best test of truth is the power of the thought to get itself accepted in the competition of the market, and that truth is the only ground upon which their wishes safely can be carried out." So here again, Justice Holmes was arguing for the marketplace of ideas, that even beyond the foundations of our faith, many may come to recognize that ultimately understanding the best way to live and making decisions for our lives has to be grounded in a system where truth can be freely discussed and freely evaluated, and that if certain ideas are withheld from the common conversation, then much like Milton and John Stuart Mill said, we do injuriously to ourselves. It hampers our own furtherment and development to hold back these ideas. Stepping back here again to look at sedition in the 20th century, the Smith Act of 1940 was passed, which said that it was a crime to conspire or advocate for the violent overthrow of the government, or to organize or be a member of a group that does. And this was really This really came about in the height of the time in the country when anti-communist sentiments were very strong. There were a few Trotskyists, a certain brand of socialists, communists that were prosecuted and convicted in 1943. And in 1948, the nation's top communist leaders were charged with advocating to overthrow the government. In 1951, the Supreme Court ruled on this case 7-2, saying that the convicted defendants had not had their First Amendment rights violated. But in 1957, the Supreme Court reversed this rule by a decision of 5-2 and said that the defendants had advocated the overthrow of the government only in the abstract, and that conviction required advocating actual action aimed at a forcible overthrow. So it wasn't enough to simply talk about it in abstract terms, that in order to be convicted of treason, to be convicted under the Smith Act, that there had to be some sort of actual action that was being advocated, and not just talking about overthrow of the government in sort of these abstract philosophical or conceptual terms. All right, so I want to turn for just a moment and look at journalism and the law in schools. Historically, parents have been given wide latitude in controlling kids' behaviors, and schools and the government have had the same sort of authority to exercise that same kind of parental control in large part. However, there was a Supreme Court case called Tinker versus Des Moines in 1969, and this dealt with a case in which on December 16, 1966, Christopher Eckhart, who was 16 at the time, and Mary Beth Tinker, who was 13, went to school wearing black homemade armbands with peace signs on them to protest the Vietnam War. Mary Beth's brother, John, who was 15, wore a similar armband the next day, and all three were suspended. The school said it was afraid they would cause violence among other students who supported the war, but in the Supreme Court case in 1969, justices ruled that the students have a First Amendment right to express themselves even on controversial subjects, as long as they do so without, quote, materially and substantially interfering with requirements of appropriate discipline in the operation of the school and without colliding with the rights of others. And so there was a famous statement that one of the justices made, saying that students do not shed their First Amendment rights at the schoolhouse gates. So many saw this as a win for free speech for students in schools. As somewhat of a contrast, in 1988 we had the case of Hazelwood School District versus Kuhlmeyer. A principal at East Hazelwood High School near St. Louis had removed 2 pages of the student newspaper where articles about teenage pregnancy and the impact of divorce on children had been published. These articles included interviews with 3 students. These were anonymous sources, but the interviews discussed how these students were affected by unwanted pregnancies. Articles also included information about birth control. They quoted anonymous sources about problems they had suffered after their parents' divorce. And school officials said that they were concerned that the identities of these anonymous students might become known, and that they said the story on divorce was unbalanced and gave only the opinion of students. Well, so in the Hazelwood case, the federal district court upheld the censorship. This was overturned on appeal, but the Supreme Court eventually reversed the appeal decision and upheld the initial decision of the federal district court, and said that the newspaper was published as part of school curriculum. The court strongly suggested that the full force of the ruling would not necessarily apply to a newspaper published as an extracurricular activity. But it also said that it was not deciding if the ruling applied to college and university papers. But the Supreme Court said that educators can have greater control over school-sponsored publications as long as there is, quote, legitimate pedagogical concerns. So where school officials have legitimate concerns about maintaining an environment of effective education, then they have latitude to censor and determine, have a say in what kind of content is published by student newspapers, at least those that are published as part of official school curriculum. Again, the court suggested that this may not apply in full to newspapers published as extracurricular activities. In 2007, we had the Supreme Court case of Morse versus Frederick. This involved a case from January 23, 2002, when students and staff at Juneau Douglas High School were allowed to leave classes and watch the Olympic torch pass by. Joseph Frederick, a student who was late to school that day, joined some of his friends on a sidewalk across the street from the high school. This was off school grounds, but Frederick and his friends waited for the TV cameras so they could then unfurl a banner that said, "Bong hits for Jesus." Frederick was quoted as later saying he'd first seen the phrase on a snowboard sticker. But when they displayed the banner, the principal at the time, Deborah Morse, ran across the street and seized the banner, took it away from him. The Supreme Court, in their 2007 decision, decided that this should be evaluated under school speech doctrines and not general free speech guidelines. So this brought in the considerations that were established in the Hazelwood case. The court also decided that the banner could be reasonably understood as advocating for illegal drugs. The majority of the justices said that the school had a legitimate pedagogical interest, so we hear the language there from the Hazelwood case, that there was a legitimate interest in protecting students against drug abuse, and this was not merely trying to avoid discomfort, which would naturally come when we have unpopular viewpoints. Those sorts of types of speech would be protected. Just because they're unpopular doesn't mean that they necessarily disrupt the educational environment of a school. But again, because there was a legitimate interest in trying to protect students against drug abuse, in this case the Supreme Court said that there was a defensible case for the school intervening and censoring the speech of students in this case. This was a split decision, however. It was a 5-4 decision, and it shows how close the case was. In his dissent, Justice Stevens said, "Admittedly, some high school students, including those who use drugs, are dumb. Most students, however, do not shed their brains at the schoolhouse gates. And most students know dumb advocacy when they see it. The notion that the message on this banner would actually persuade either the average student or even the dumbest one to change his or her behavior is most implausible." So when we see close decisions like this, a split decision, 5-4 decision, where the majority is only one vote away from those in opposition to the decision of the court. These dissenting opinions can carry a significant amount of weight when it comes to legal precedent. So oftentimes attorneys will appeal to these dissents to try to establish certain legal precedent in future cases. Now, this is clearly a pretty short shrift in discussing scholastic journalism, student journalism, and the laws that surround it. However, these are some of the pretty significant landmark cases that are often brought up when we talk about students' rights and student journalism or student speech. So we'll move on next time, and we'll start looking at issues of libel and invasion of privacy and that sort of thing. But hopefully this establishes a foundation for talking about journalists and the law.